So thank you everybody for coming to this lunchtime seminar for the Health Law and Ethics Network. We hope that you are all doing well, and for those in Victoria that things have become a bit easier since we came out of lockdown. We'd like to acknowledge the Wurundjeri people of the Kulin Nation, who are the custodians of the land on which Melbourne Law School stands. We acknowledge their leaders, past, present and emerging, and we pay our respects to that group of Indigenous people, but also to groups of Indigenous people wherever you are standing today. We're very pleased to present this lunchtime seminar. We have two fantastic speakers. So the topic today is personality disorders and sentencing, where to from here. And we have Dr. Andrew Carroll and Dr. Jamie Walvish. So Dr. Carroll is a forensic scientist. He currently is a consulting psychiatrist for forensic care, and he serves the Ararat Correctional Facility. He's been a forensic psychiatrist for over 25 years, working in Australia and the UK. He has an associate professor role at Swinburne University in psychiatry, and he has an honorary role in the Department of Psychiatry at the University of Melbourne. He works with Dr. Jamie Walvish, who is a senior lecturer at Melbourne Law School, and Jamie's work sits at the intersection of law, psychology and psychiatry with a focus on sentencing. So we welcome our presenters today, and we welcome everybody in the audience. We're looking forward to a really excellent seminar. So I'm going to hand over to Andy now, and he'll speak first, I think that's correct, and then followed by Jamie, and then we'll have a really good amount of time for a question and answer session. So thank you to you both.
Okay, thanks very much, Paula, and thanks for the opportunity to present again to the Health Law and Ethics Network. So personality disorders and sentencing, where to from here? So this will be a bit of a tag team approach from myself and Jamie. I'll kick off with a very, very brief intro to the nature of personality disorders. Then Jamie will take over and talk a bit about the jurisprudence around personality disorders and sentencing and flag some of the issues. And then we'll be exploring what's happened since Brown and get into hopefully some debate around emerging philosophical and policy issues that follow from all of that. So what are personality disorders? Well, mental disorders in general, of course, are simply defined in DSM, the Diagnostic Manual, as clinically significant syndromes that involve a disturbance in thinking, emotional regulation, or behaviour. So a very broad category. And personality disorders essentially are simply a subset of that category, distinct from, but not entirely dissimilar from mental illnesses, neurodevelopmental disorders, neurocognitive disorders and such like. When we're making a diagnosis of personality disorder, it's useful to think in terms of the 3 Ps, which are outlined in the ICD-11 approach to personality disorder. So they're characterized by problems in functioning of aspects of the self and or interpersonal functioning. And these problems are persistent. Generally, we think of personality disorders as having onset around adolescence, but to meet diagnostic criteria, they certainly need to persist for at least 2 years or more. And they are pervasive. It's not enough that someone's functioning is dysfunctional in one particular context, such as perhaps an occupational context. The problems of personality disorder are manifest in a range of different situations, and so they are pervasive. So there we have the 3 Ps. So the key distinguishing aspect, and from a jurisprudence point of view, this is the important point to get across, as will become clear from Jamie's presentation, is not that personality disorders are any less impactful in terms of their effects on functioning and distress as compared to, say, mental illnesses, but rather that they have greater temporal stability. They tend to persist over time. I'll now hand over to Jamie to provide us with a brief history on the sentencing of offenders with personality disorder.
Thanks, Andy. Hi, everyone. Hopefully you can all hear me. Thanks for coming along today. Thanks to Michelle and Paula and the rest of HLEN for organising this seminar. I'd like to start by acknowledging that I am also working on the lands of the Wurundjeri people of the Kulin Nation, and to pay my respects to their elders past, present and emerging, and extend that respect to any Aboriginal and Torres Strait Islander people who are here today. And thanks, Andy, for providing a clear introduction to the presentation and explaining the nature of personality disorders. I'm now going to do the legal introduction and explain the way in which personality disorders are currently taken into account in sentencing. Excuse me. And the starting point here has to be the Victorian Court of Appeal's landmark 2007 decision, the Queen against Verdens. So for those of you who aren't familiar with this, this was a case in which the court identified 6 ways in which mental health problems can mitigate a sentence. So they can reduce the culpability for the offence, and so this affects the calculation of what's considered to be just punishment or the need to denounce the offender's conduct so strongly. They can affect the kind of sentence that should be given. So, for example, it might be appropriate to give a community-based order with a mental health treatment requirement. They can moderate or eliminate the need for general or specific deterrence as sentencing considerations, or they can affect a person's experience of punishment. So either due to the sentence weighing more heavily on them or due to a likely deterioration of their mental health while in prison. And where this is the case, the sentence should be reduced to ensure that they don't suffer a disproportionate burden. These principles, which are now known as the Verdens principles, have been adopted in all Australian jurisdictions, as well as in New Zealand. Now, in subsequent cases, it's been made clear that these aren't the only ways in which an offender's mental health can affect the sentencing determination. It can also affect their perceived prospects for rehabilitation, as well as the potential need for community protection. Now, the Verdens principles were stated to apply whenever the offender was shown to have been suffering at the time of the offence or at the time of sentencing from a mental disorder or abnormality or an impairment of mental function. And the court in Verdens made it clear that this was intended to be a broad definition. So, for example, there's no need for there to be a diagnosable mental illness or for the illness to be of a particular level of gravity. What matters is what the evidence shows about the nature, the extent, and the effect of the mental impairment that was experienced by the offender at the relevant time. And in the cases following Verdens, the principles have been applied to a wide range of conditions such as schizophrenia, depression, bipolar disorder, intellectual disability, acquired brain injuries, PTSD, and so on. There has, however, always been, excuse me, a bit of a lack of clarity concerning personality disorders. So these disorders weren't explicitly mentioned in Verdens, although in that case they did mention with approval a couple of cases where personality disorders, the principles had been applied to offenders with personality disorders. But in the years following Verdens, some cases applied the principles to personality disorders, some cases didn't, and there was a general level of confusion. This was initially resolved in 2015 in the case of O'Neill, where the Victorian Court of Appeal held that personality disorders were excluded from the scope of the Verdens principles. And they did so on the basis that they didn't consider personality disorders to be illnesses which impact upon the capacity of affected individuals to perceive the world around them or to respond to it. And so they didn't think that personality disorders constituted a mental disorder or an abnormality or an impairment of mental function. Now, Andy and I and many others working in the field had significant concerns about this judgment. It appeared to demonstrate a real lack of understanding of the nature of personality disorders, which, as you've just heard from Andy, can adversely affect a person's perception of the world and their response to it. And this is, in fact, the very reason why they're considered to be disorders. It also minimised the potential impact of personality disorders, which can significantly impair a person's mental functioning. And these misunderstandings and the limitation of the operation of the Verdon's principles seem to us that are likely to prevent the courts from being able to appropriately tailor sentences to meet specific offenders' needs, for example, by ordering treatment for personality disorders that have been shown to be effective. So Andy and I wrote about the issue and in conjunction with Victoria Legal Aid embarked on a strategic law reform campaign, which was ultimately successful. And in August last year, the Victorian Court of Appeal convened a 5-judge bench to reconsider the issue. And in the case of Brown, they overturned O'Neill. And they accepted that personality disorders can severely impair an individual's mental functioning and so can fall within the scope of the Verdon's principles. And you can see from the passage on this slide here that personality disorders should now be treated in the same way as any other mental health problem. So the key question is not the diagnostic label that's applied to the offender's condition, but the effect that condition had on their mental functioning at the time of the offence or continues to have at the time of sentencing. So that's the key kind of legal and psychiatric background to the main issue that we want to look at today, which is what's happened since Brown. And in this regard, I just want to quickly raise a few concerns, flag a few concerns that were raised by the case before handing back over to Andy. And the first was a concern that the Brown decision was going to open the floodgates to a rush of unjustified claims of mitigation. And this was seen to be a risk because of the high number of offenders with personality disorders. So while the data in this area lacks specificity, it does appear that between 40 and 65% of offenders have been diagnosed with a personality disorder. And it was now feared that they would all start raising their disorder to mitigate their sentences. Concerns were also raised about the appropriate treatment of offenders with antisocial personality disorder, or ASPD, in the sentencing context. And there are really two concerns that are being expressed here. The first relates to the circularity of relying on ASPD to mitigate sentencing, given that part of the diagnostic criteria for ASPD relate to offending behaviour. So this can lead to a situation where you say, this person's been diagnosed with ASPD due to their persistent offending, and the reason for their persistent offending is their ASPD, which is clearly circular reasoning. The second relates to the fact that ASPD is about an individual's behaviours rather than their cognitive or volitional capacities. It's been suggested that ASPD is really just a description of maladaptive behaviour rather than an impairment of mental functioning. And so it's been argued that it should be treated differently from other personality disorders like borderline personality disorder or paranoid personality disorder, which clearly do affect an individual's cognitive or volitional capacities. And the third issue raised by the Brown decision is whether it's actually appropriate for personality disorders to reduce an offender's culpability given their persistent nature. So that's enough from me for now. I will now pass back over to Andy to have a look at what's happened since Brown.
Thanks, Jamie. So what's happened since Brown? Well, the first thing to say, and probably the most important thing to say, is that the floodgates have held firm, at least from the point of view of the higher courts, where we can review sentencing comments on Ostley and Jade. there doesn't seem to have been a flood of unjustified claims of mitigation. And I just want to maybe have a bit of a think about why that might be. And it seems to me that part of the reason is that there are, you know, as well as the good sense of the Victorian judiciary and indeed the Australian judiciary, is that there were some very clear barriers to mitigation, which are particularly evident with respect to personality disorder. The first is what you might call the severity threshold, and the appeal court talked about, in the Brown ruling, talked about personality disorder only being relevant in a case of some severity, whilst of course being very careful not to specify exactly what that severity might be. But nonetheless, it wasn't just any old kind of mild personality quirk that would qualify. The second point was that, at least with respect to the Verdin's issues relating to culpability, moral culpability, and to deterrence, Justice Taft, in the initial Brown ruling in the county court, said that there needed to be a connection of that disorder to the offending, and that was certainly endorsed by the appeal court. So the causal link barrier. Justice Taft also talked about the need for cogent evidence, and again, this was echoed in the appeal court in Brown. So the evidence had to be cogent, that's to say, clear and convincing. And finally, as the appeal court made clear, there is something of a sting in the tail in the Brown ruling. They pointed out quite sensibly that, of course, if you've got an enduring problem such as a personality disorder that is causally linked or likely to be causally linked to the offending, then the issue of community protection and perhaps the need to increase the sentence for that reason is likely to arise quite frequently. What I want to briefly look at now is what you might call a garden variety violent offence, which was recently went to sentencing in DPP versus Olive. Now, there have been some high-profile cases in recent years involving personality disorder, most notably, of course, O'Neill, but also Cody Herman and Jamie Lee Dolgai. But I think there is some merit in just looking at a more common type of offending, in this case, domestic violence, to see, to illustrate some of these issues, and particularly to look at these barriers to mitigation. So Mr. Olive is a 30-year-old who was savagely violent towards his 22-year-old sister when in a state of methamphetamine intoxication on the background of a substance use disorder. It was essentially an act of impulsive violence after he was asked to pick up some clothing at home. And he attracted a range of charges as a result. I think he was also violent towards his father in the same sort of spree. So the severity threshold, well, Dr. Prashant Pandurangi was the defence expert. Prashant's a very experienced forensic psychiatrist, and he used the ICD-11 framework in conjunction with a scale derived in the DSM-5, the level of personality functioning scale, to determine severity. And he concluded that Mr. Olive's personality disorder was moderate, but that the impact on his functioning was actually quite severe. And he pointed out that there were prominent traits of detachment, dissociality, and disinhibition. Next, the causal link. So Justice Lyon, in his comments, noted that Prashant found that the actions were affected by personality disorder and drug use, that detrimentally affected but did not dictate the offender's decision-making. The decision-making was poor and impulsive, and there was a reduced ability to manage anger and emotions. And of course, this is a very common pattern in violent offenders. And His Honour found that this should moderate to some degree general and specific deterrence. So the idea was that the personality disorder and the drug use were necessary but not sufficient factors to explain the offending, and Mr. Olive would have certainly known that what he was doing was wrongful. The evidence was found to be cogent, not surprisingly. Dr. Pandurangi is a very experienced forensic psychiatrist. He did a very thorough job. He had all of the relevant collateral files to draw upon. did a very thorough assessment using a validated diagnostic framework, and he integrated evidence from the prison clinical files as well. So the evidence was found to be cogent. And Justice Lyon did take into account the notion of community protection and pointed out that he was somewhat guarded about the prospects for rehabilitation. This was not Mr. Olive's first offending. And he pointed out the need to address his psychological and drug issues in order to improve his prospects of rehabilitation. And this links to what some of the themes that Jamie and myself want to draw upon for the conclusion of this presentation. So on that, I'll hand back over to Jamie to look at some philosophical and policy questions.
Thanks, Andy. So I'm going to just finish up my part of this presentation by looking at the issue of moral culpability that's raised by these cases. And when we talk about moral culpability, what we're really talking about is the extent to which a person should be held responsible for their actions or the level of their blameworthiness. And this assessment affects the amount of punishment that we think it's appropriate to impose, as well as the extent to which we think their behaviour should be denounced. Now, in Verdens, the court held that an offender's moral culpability may be reduced if their condition had certain effects on their mental functioning at the time of the offence, such as impairing their ability to exercise appropriate judgment or to make calm and rational choices or to think clearly, and that there was a sufficient connection between their condition and their offending behaviour. But what I'm interested in is whether that's enough, or whether in assessing an offender's culpability, the court should also consider whether they've failed to take sufficient steps to address their disorder. While this is a question that could obviously be asked in relation to any mental health problem, I think it has particular pertinence in the personality disorder context, given the persistent nature of these disorders as Andy described them, and thus the extended period of time that individuals have to take steps to address their disorder. And I think there are two strands of theory that can be drawn on to answer this question. So the first is Fisher and Ravitza's tracing approach to moral responsibility. So in developing this approach, Fisher and Ravitza draw a distinction between historical phenomena, so these are things which depend in some interesting way on features of their history, such as the fact that a painting is a genuine Picasso. You can't tell that just by looking at it, but you need to know about the history and provenance of the painting. Or non-historical or current time slice phenomena, which depend solely upon snapshot properties, such as the fact that a painting is blue. Now, it's my view that culpability in the sentencing context is a historical phenomenon. And in assessing culpability, the focus is on the wrongful nature of criminal actions. And this is a matter that can't be determined simply by considering a snapshot of those actions. And this can be seen by considering the example of a woman who kills her violent partner after years of abuse. It's not possible to determine the reasonableness or the wrongfulness of her action, rather, simply by looking at the killing itself. Determining its wrongfulness requires knowledge of matters such as the history of violence that she suffered and the psychological effects that it had on her, and so on. The second theory that I want to draw on here is Anthony Duff's theory of prospective and retrospective responsibilities. So prospective responsibilities are the matters that an individual must attend to in the future. And these responsibilities arise due to the normatively significant descriptions that a person satisfies, such as a parent or a teacher. So it's only when a person has a prospective responsibility to attend to a certain matter that they can be called to account for the way in which they have attended to it and be held retrospectively responsible for any problems that have arisen. So in other words, retrospective responsibility depends on prospective responsibility. So to give you an example of what I'm talking about here, as a university lecturer, I only owe responsibilities to a limited class of people, such as my students, my colleagues, my employer. And I can justifiably dismiss any attempts by other people to try to call me to account if I perform my duties poorly. The scope of my responsibilities is restricted to matters relating to teaching, research, and service, such as conducting effective classes and writing articles. So I'm not responsible as a lecturer for matters that fall outside the scope of my lecturing duties, like attending church. So even my students, colleagues, and employers, to who I do owe some responsibility, can't call me to account for failing to go to church. And if they try, I can justifiably tell them it's none of your business. So hopefully you can see here that a lot depends on the nature and the scope of the normatively significant description that's in issue. For example, my prospective and thus retrospective responsibilities as a parent differ from my responsibilities as a lecturer, both in terms of the extent of those responsibilities, as well as the people to whom they are owed. Now, in the context of the criminal law, Duff argues that offenders should typically be held responsible by virtue of their status as citizens. Because citizens owe each other equal concern and respect, they have the prospective responsibility to be aware of the interests of those around them and to take care not to harm them or to treat them in ways which are inconsistent with the community's values. And if a citizen breaches these obligations by acting in a way that's identified by the criminal law to be a public wrong, they can properly be held retrospectively responsible for their actions by the state. Following on with this idea, I think it's arguable that some individuals with personality disorders will have a prospective responsibility to seek treatment for their condition. This will be the case if they're aware that they have a personality disorder and that it creates a significant risk to others. As citizens, they have a responsibility, an obligation to seek treatment in order to reduce that risk. And if they fail to do so, they may be held fully culpable for the resulting offence, despite their impaired mental functioning. And this is because culpability is a historical phenomenon, which should be assessed not just by considering whether the offender's mental functioning was impaired, but also by considering the cause of that impairment and the steps that the offender took to address it. I note, however, that this is not a straightforward issue. I don't think we can simply say to somebody, well, you failed to treat your personality disorder, so you need to be held responsible for the consequences. A proper assessment of culpability also requires the judge to take into account the reasons why the offender failed to seek treatment. And this could be things like the fact that they lacked insight into their condition or were unable to access treatment or couldn't afford their treatment or so on. So it's quite a nuanced approach, but one that focuses on the history rather than simply the fact of their impaired mental functioning. Now, in this regard, I think it's important to emphasize the fact that responsibility isn't a one-way street. While citizens have a responsibility to look out for each other, the state also owes its citizens various responsibilities, which will be relevant to this assessment. So, for example, if the state has failed to provide the resources or the support necessary for the offender to obtain their treatment, then the offender's failure to get treatment shouldn't be held against them. And I'll note that this issue was alluded to in the Cody Herman case that Andy mentioned by the Victorian Court of Appeal, which concluded with these two passages that are on the slide. And you'll see that they refer to the responsibility the state has to ensure that treatment is made available in prison, as well as part of the rehabilitation regime. But I'd suggest that this obligation goes further and extends to providing adequate care and support before the offending as well. That's all I'm going to say for now, but I'll happily take questions on this, but I will pass over to Andy to finish up.
So I guess in summary, what we're saying is that the issues around sentencing and rehabilitation around offenders with personality disorder really helps us to clarify the road forward for rehabilitation in general. And one of the reasons that we were especially concerned about the O'Neill ruling, which would have basically negated any consideration of personality disorder under Verdin's, was that it kind of would let society off, let government at least off the hook with respect to a lot of its responsibilities towards offenders. What we would have ended up with under a kind of O'Neill-driven regime would have been expert evidence that tended to ignore personality variables, and hence would end up being somewhat anemic in terms of its formulations and in terms of recommendations for rehabilitation. The ideal, of course, has to be around us all working together for public safety. So rehabilitative services, mental health services, the courts, the parole board, the offender themselves, and what goes on inside the prisons, ideally would all kind of interdigitate, synchronize and synergize with the aim of working towards public safety. Now, any of us working within the system know that this is not what happens. Occasionally, 2 or sometimes 3 of these wheels will briefly interdigitate for a brief period of time. But the idea that we have a system that works perfectly in this way much, or even, certainly not most of the time, I think it is all a bit of a fantasy at the moment. What we're emphasising, as Jamie said, is that the road to public safety is really a two-way street. We can talk about offenders having responsibility to seek help, to engage with processes, to engage with pro-social peers and such like, to engage with society in general. But conversely, society has obligations to provide access to high quality interventions. At the moment in Victoria, society is lamentably failing to do this for personality disordered offenders. Society is failing to engage adequately with that group, and I would say is failing in its responsibility to offenders, and this is not helpful towards public safety. So we'll have a bit of time for discussion now. Our email addresses are there if any thoughts or any queries arise after this talk. I'd be more than happy to receive emails from anyone, but I'll stop the share now and we can hopefully have a bit of a discussion.
Thanks very much, Andy and Jamie. That was a fabulous presentation. So I'll open it up now for questions from the group. So if you would either like to put your question in the chat, or if you'd like to put up your hand, either is fine for you to be able to ask your question. Thanks, Janine. Would you like to ask your question?
Thank you. I'm a criminal defence barrister, and I'd be interested to know what Andy and Jamie say about the aspect of the offender finding it very difficult to accept or access appropriate treatment as a result of them having the personality disorder. Because in my experience, I've had many, many clients who have that, and you tell them, what to do, so to speak. I know it sounds easy, and you explain, I know it's hard, but even if you direct them towards appropriate services or particular doctors or agencies, they very often won't do what they're advised to do. Is there some advice that would assist in advising them?
Yeah, look, I mean, if I could solve that particular conundrum, I'd you know, I'd be a rich man probably. So, I mean, in terms of the jargon around rehabilitation, I think a useful term is that of responsivity, because, you know, the risk needs responsivity model, I'm sure many in this audience will be familiar with, huge evidence base around offender rehabilitation. We tend to think of, you know, dysfunctional personality traits and attitudes and such like as being risk needs, as things that we have to target. So, for example, the propensity to impulsive violence, poor problem solving, things like that. Yes, they are risk needs. They're criminogenic needs that we can target with evidence-based programs and individualized therapy and all the rest of it. But the problem with personality disorder is that it's kind of got this double-edged quality in that, as you've kind of alluded to there, Janine, it's also a responsivity factor. There is something about it that means that the way that services are delivered and presented to the person need to be tailored in such a way that take account of that person's personality features. So sort of standardized therapy provided by people who are not experienced in, particularly in sort of forensic mental health, will often not meet the mark for this group. And that's one of the problems we've got with our system at the moment, is that certainly at the lower levels of severity of offending, you get magistrates saying, oh, well, go out and get a mental health plan from your doctor and go off and see a psychologist under Medicare. Now, that may or may not work out well, because the psychologist that's being seen may or may not have the requisite skill set. So I think that is a big problem, and I suspect, Janine, some of the people that you've seen have probably gone along to see someone who has kind of reacted badly in terms of being confronted with a person with personality disorder, and that sort of responsivity issue hasn't been addressed, and so things just haven't worked terribly well. The evidence-based program for offenders with personality disorder kind of take this into account, and certainly, you know, the group programs in the prisons in Victoria, which, you know, I think a lot of them are very effective and do have a good evidence base, certainly take into account that difficulty with engagement. Jamie, I don't know if you had something to add to all of that.
No, I think that's a pretty comprehensive answer. I think it's more a psychiatric issue than a legal issue to an extent. I mean, obviously there are legal consequences for failing to do so potentially, which I guess, you know, can be stressed, but it's not, as you're pointing out here, entirely kind of rational decision making that's going on, which is what kind of complicates the picture significantly.
Thanks, Jamie and Andy. So we've got a question from Piers next. Dr. Piers Gooding.
Yes, hi. I can't turn on my video, apologies. But I understand that there are debates in psychology and psychiatry that these are arguably not disorders of the personality per se, but rather psychological reactions to trauma in the context of other vulnerability factors. Does that kind of interplay between, you know, diagnoses like borderline personality disorder and others like complex post-traumatic stress disorder play out in court decisions, or is that an issue that's coming up in any of your research? It's an excellent presentation, by the way.
Shall I maybe take that one initially, JB?
Sure.
Look, I mean, It's certainly an interesting debate, and one that's active in mental health. Is that, and I've certainly had some fairly robust debates with colleagues of an analytical bent who insist on calling personality disorders complex trauma disorders. There's an important distinction to be had between the phenomenology of a mental disorder, that's to say its manifestations, and the etiology of that disorder. And it's not helpful in my mind to mix the two up. It's certainly the case that many, probably most offenders with personality disorder will have a significant trauma history. Most offenders in general have a significant trauma history, but it's not the case that all of them do. And I've seen some real damage be done by assumptions being made that someone must have had a dreadful trauma history to end up with this unusual personality. You know, personality and its disorders are a combination of nature and nurture, and it's not helpful to assume that there's always a trauma history there. Now, it's perfectly possible to have, both complex post-traumatic stress disorder, which is defined in ICD-11, together with a personality disorder. And, in terms of how the courts will think about these issues, I think, and Jamie might want to add to this, I think it's perhaps a useful case to look at is that of Cody Herman, where the courts drew upon both Verdin's and the Bugmy case, Bugmy, to kind of allow some mitigation based on Cody's dreadful history of trauma and neglect. So it's certainly a live issue, and I think a high quality expert will talk about not only the manifestations of personality disorder, but also some etiological formulation as to what has led to that. So, and certainly in the Herman case, it was possible to do that because we had so much information about Cody's early years.
Yeah, I mean, again, I don't have a whole lot to add, but I guess what I'll say is I do think that the kind of better cases that are following the spirit of what, Verdens and Brown were intended to do won't be drawing a distinction based on whether it is some kind of complex trauma that's caused it or some other thing. What they're focusing on is the effects of the symptoms on the offender's behaviour or their likely behaviour going forwards. And so, that's, I guess, what Brown is really trying to get the expert evidence to focus on is how did this affect them, not the kind of diagnostic label. But as Andy's pointed out, and I think it's an interesting strand of jurisprudence that's really only started in the last year or two, is, in a very large number of Verdens cases now, you do have the Bugmy considerations raised, and Bugmy was about the need to take into account, troubled childhood trauma and background and disadvantage and history, and the courts are really starting to acknowledge the overlap between these two factors in the way that they deal with it, and we'll often consider them kind of hand in hand together.
Thanks, Jamie and Andy. Associate Professor Michelle Taylor-Sands. Thanks, Michelle.
Thanks, Paula. And thanks, Andy and Jamie. Can you hear me? Yeah, okay, great. It's a fascinating topic, really great presentations. I just had a question around the concept of prospective responsibility, and it sort of ties into what Piers raised, but also what Andy was talking about as well, about sort of the responsivity of surfaces. I mean, it seems a little bit problematic to me, and I sort of say, is it sort of morally significant? Because some of the examples that you mentioned, Jamie, about prospective responsibility were really things that people had chosen. So you choose to be a parent, you choose to be an academic, you choose to be a doctor. But we're talking about individuals that haven't really chosen their situation in life. And I guess that sort of combining that with, an inability because of that, what they're suffering from to access, whether it be via insight or resources or, a multitude of things, actually meaningfully access support, and also what Andy was talking about, having a responsive support environment, which we know we don't have. So I guess there's a combination of all of those things. And I know you did mention it was nuanced, but are there sort of so many barriers in that equation that it makes the concept of prospective responsibility for these individuals almost not that meaningful at where we're at the moment?
Thanks, Michelle. It's a good question. And I mean, it's a difficult question to answer. I guess the point that I will make, the first point I will make is that the idea of prospective responsibilities in this context, I appreciate, the examples I gave were, choice-based ones, but here it's not about their kind of condition, it's about the fact that they're citizens and that we're all citizens kind of trying to work out a way to live together in society. And really, it's based on a kind of deeper Republican political theory about what our society should look like and what obligations we all owe to each other by virtue of living in this society. And maybe, there can be obvious disagreements about what the scope of those obligations are, but I think if we are going to look for some kind of principled foundation for having a criminal law in the first place, we have to accept that we have some kind of obligations that arise from something, and citizenship to me seems as good a kind of place to start as anything else. But as you point out, the real problem here is the state is really not upholding its side of the bargain to an enormous extent. And so that's why, yes, to an extent, maybe you're right, maybe it doesn't get us very far at the moment, but I think what it can do is make clear who owes what obligations and where those obligations are being let down in the way that we think about this and assess it. And I guess the good thing about culpability, as opposed to something like criminal responsibility, which is a kind of all or nothing decision, either you're criminally responsible or you're not. Culpability is a very graduated concept, which means that you can have greater or lesser extents. And so you can say, well, look, the state is the one who's really responsible here. And so that significantly diminishes your responsibility. But you did still have some responsibility, and you also didn't do your part. And so you retain some level of responsibility for that, which is a kind of basis on which we will proceed. I don't know if that kind of answers your question at all.
No, it's complex, but thanks, it does. It's great.
Andy, did you have anything to add to that question?
No, that's, I've just added to the chat function the link to the registration page for a conference that's happening this Saturday, at which Jamie is one of the keynote speakers, on this notion of criminal responsibility and emerging themes in criminal responsibility and mental health. And we'll be exploring, issues akin to this in more detail. There's still online places available. And for those of you who can't make it in real time, a recording will be available for all registrants. And I'd say it's a bargain at $50. So I'm just taking the opportunity to do a bit more spruiking for it's jointly by ANZAPL and the Royal College of Psychiatrists Forensic Faculty.
Thanks, Andy. That's excellent. We have a interesting question in the chat from Melissa Wood, who asked if you had any thoughts on what Brown might mean in future for some other disorders that have been deemed not relevant to enlivening verdens.
Yeah. Look, the obvious one here, and I'll hand over to Jamie to give his comments on this as well in a moment. The obvious one here, I think, is substance use disorder. I don't know whether Melissa had that in mind when she's put the question up there. Kate Sear is one of the speakers this Saturday. So if you want to see that issue explored in more detail, then log on. Look, who knows? It's going to be a very interesting one, isn't it? And the amazing work at Turning Point, led by Dan Lugman and others, in an attempt to sort of shift societal views around addictions. It's going to be really interesting to see where that goes, whether there'll be some kind of equivalent to Brown that kind of overturns the way addictions are currently viewed with respect to sentencing, which I think is more or less as an aggravating factor. But I'll hand over to Jamie and see what he has to say on this.
Thanks, Andy. Look, I think verdance has generally been interpreted broadly other than personality disorders. And so, as Andy says, substance use disorders are one thing that have so far been excluded. I think that's not so much because they're not considered to be disorders, though that might be the case, but I think it's about the history of the way that the law has developed in relation to intoxication, which has been quite a separate strand of the development of the law and has had its own principles that were developed to deal with the difference between intoxication and addiction and so on. I'm not sure we will see a merging of that strand of law and the kind of Verdon strand of law, but perhaps it's possible in light of Brown. The only other disorders that I'm aware of that have really not been accepted as part of Verdon's have been the disorders like pedophilia. So sexual, the sexual sadism disorder or so on. And again, I'm not sure we'll see much of a development in that area simply because of the kind of two-edged sword that Andy raised, which is you might try to say, well, I had one of these disorders and that's mitigating, but the court's going to, in all likelihood, say that's well and true, but the need for community protection is significantly enhanced here. So any mitigating, factor is going to be more than offset by the need for community protection. I see in the comments that you're talking about adjustment disorder. Adjustment disorders have been accepted under Verdon's, and interestingly, they've been accepted even where it's clear that the adjustment disorder has arisen as a result of being charged with the offence and sentenced to prison. The courts have still been willing to accept that this can have an impact on a person and particularly on their experience of imprisonment, and have mitigated accordingly. But I mean, I would hope that it does actually change any kind of other disorders, because, it really shouldn't be about labels. It should be about effects, but we'll see.
And I think following on from that, we tend to think, and particularly defence lawyers tend to think of verdicts as being all about mitigation, getting the magic number reduced by some percentage. Bear in mind that one of the key things in verdicts was always about type of sentence. So it explicitly linked to what can we do about, how can we shape the sentence based on someone's mental health needs for the good of not just the offender, but also society. So I think we kind of missed a trick when we bluntly think about verdicts as all about mitigation. So for example, if you had, if say disorders of sexual preference came into it, you could envisage a system where it's not simply about reducing the tariff, but perhaps more about, well, maybe we need to shape this sentence so that the person gets into a sex offender program early on in their sentence rather than waiting until they apply for parole, as is currently the slightly bizarre system that we have in Victoria. So I'm just kind of thinking out loud here, but that's my views on the matter.
Thank you. So we're quite close to time now, so I think it's a very good point at which to end. I'd like to thank you both for a fantastic presentation and for you know, being part of an excellent Q&A session. So we had some great questions, and thanks for answering them in such a fulsome way. So if you do have any comments or questions, please feel free to send them through to Jamie and Andy. They did have their emails on the slide. And thank you very much to everyone for coming to this HLEN seminar. So the next seminar will be next month on the first Tuesday of the month. So we're starting back for the seminars running through to the end of the year. So thank you very much, everyone. Please join me in thanking the speakers.